SJC-13652, Commonwealth versus Brendan J. Garafalo, and 9 companion cases.
Attorney Campbell.
Good morning. May it please the Court, Julianne Campbell on behalf of the Commonwealth. I'm here today asking that this Court vacate the Superior Court's allowance of the defendant's motions to dismiss because according to this Court's own precedent and the plain language of the human trafficking statute, the grand jury in this case heard evidence that established probable cause that each of these defendants attempted to entice, recruit, or obtain by any means another human being for purposes of commercial sexual services. With respect to that, Your Honors, I'd suggest that in the light most favorable to the Commonwealth, the evidence here at a minimum established that these defendants attempted to hire another human being to perform services, specifically commercial sexual services.
Hiring is different than recruitment or enticement, correct?
Your Honors, with respect to this Court's definition of recruit in Commonwealth v. Dabney, which I believe Your Honor was the author of that opinion, this Court defined recruit as to hire for services. So applying that definition according to this Court's own precedent, the evidence that this grand jury heard where these defendants attempted to hire a person for commercial sexual services, there was certainly probable cause that they committed the offense of human trafficking. I'd suggest that that's one avenue that supports the Commonwealth's theory of the case, perhaps the most clear. I'd also suggest that obtained by any means, which is certainly broad language in keeping with the statute itself, which this Court has acknowledged is a broad statute, that the defendants attempted to obtain by any means, in this case by paying an individual, attempted to obtain another human being for commercial sexual services.
So to me, I think that's your strongest argument, the obtain, not so much the entice, which I think has some element of, I don't know, wooing in some way. And I also think recruit requires some effort to bring the person in, and I think responding to an ad is not either of those things. But certainly obtain has a broad meaning to get, essentially. And they were seeking to get this person.
And I would acknowledge that I think the Commonwealth's theory on enticement is perhaps the weakest of the three that the Commonwealth advances. However, again, I'd suggest that there are two other avenues, and I take the Court's point with respect to recruit. However, I am relying on this Court's interpretation.
Well, what if you relied on the dictionary definition? Does the dictionary say that recruiting is just hiring somebody who is responding to an ad? So let's say I put an ad out to sell my car, and somebody responds. Yes. Are they recruiting me to sell my car? So
in Dabney, this Court relied on this.
Are they recruiting me to sell my car? I put an ad out, I'm selling a car.
Well, it's not, I would suggest in that, so I'd like to answer that in that I don't, in my reply brief, I suggest that a general offer is not an offer within the meaning. However, recruit would not apply because it's for hiring for services as opposed to obtaining an object in Your Honor's hypothetical. But with respect to the broader question of whether an advertisement is an offer, under, as I argue in my reply brief, under general principles of contract law, and I do cite cases in my reply brief, an advertisement is not an offer under contract principles. It is an invitation for offers. And in this case, I would suggest that these defendants while there was an while there was an advertisement inviting offers, it was these defendants who reached out with the specifics that they were looking for, how much time they were looking for, what services, specific sexual acts they were looking for. And in that respect,
the ad, let's call it that, delineated specific services.
Your Honor, the ads themselves are in the Commonwealth's impounded record appendix.
Yeah.
They list a variety of services.
Right.
And so, but again, and I point to the cases cited in the Commonwealth's brief, an advertisement for a list of services in general context is never understood to be an offer. It is an invitation for offers. And I would suggest that this context should not have some other specific interpretation simply because it involves an advertisement of a human being.
Could you expand your, are you done? Sorry.
Well, I was going to ask you, so in Dabney, it was a recruitment by money. The person was hired to perform this. In this case, the sexually trafficked people are already on board. They don't need to be recruited. They're in place. So isn't that a distinction?
It's not, and I would again point to Dabney and where Your Honor wrote for this court that even in an instance in which merely assisting an adult consenting prostitute will still constitute the crime of sex trafficking in those circumstances where all the statutory elements are met. Here I would suggest that the actus reus of obtaining by any means or hiring someone for services is satisfied, and the mens rea is knowingly. And these defendants, in the light most favorable to the Commonwealth, knowingly reached out, knowingly specified the terms of the offer that they were looking to satisfy, and
So every John is a trafficker, and is that right? I'm just trying to understand, because we're doubling the penalty, right? There's a penalty for being a John that's 2.5 years. This is a 5-year penalty, is that right?
and I appreciate that Your Honor is asking about the penalty, but I would.
Well, I'm confused. I'm not sure I understand whether this is, to me, there are trafficking statutes and there are John statutes, and you're basically turning every John statute into a trafficking statute. Are you? I mean,
I hear what Your Honor's saying.
Is there a John that isn't a trafficker under your view? I understand
No.
they're contributing to, they're commercializing sex but at least the layperson's understanding of trafficking versus being a John, traffickers they're getting a mandatory minimum 5-year penalty. They're a different category of evil, I thought.
And I appreciate Your Honor's point with respect to that. And if I may answer.
It's a question. I just don't understand. To me, you're collapsing the John statutes and the trafficking statutes. That may be correct, but I don't know why.
And if I may respond. So first, I'd suggest that the sex for a fee statute and the human trafficking statute are separate in that sex for a fee requires that a fee be provided. The human trafficking statute, there is no requirement that a thing of value.
Seems silly. I mean, of course they're paying in some. That can't be what we're really.
Your Honor, if I may continue, that is one significant difference in that human beings are often trafficked by individuals and are not compensated in any way in a broader term. Beyond that, Your Honor is considering, and I think this is part of the error of the appeals court in how it defined obtains, Your Honor is considering a colloquial idea on how we have historically thought of trafficking.
But it's also the plain meaning. The word trafficking appears in this statute, right?
But that's not the word that is the name of the statute. That is not the words that the legislature used to enact what constitutes human trafficking, and it is not the language that the Commonwealth is using in its theory of the case here.
I'm sorry. Go ahead.
There's an issue about whether or not the appeals court added an element of predisposition, which is what the AG brings up and you
Yes.
bring up. Put that aside. The issue we have is legislative intent, to see whether or not the legislature intended this statute to reach so broad as to as to ensnare people who are hirers of sexual services. When we look at the words, it's force, coerce, or obtain. Don't we have to judge the words in context? We always say that the words in the statute are judged by the company they keep. So there's coercion, there's enticement, and there's obtainment. Those, to me, all indicate the traditional person who hires, entices people to be to prostitute themselves.
If I may respond in two parts. One, fraud, force, and coercion do not appear in the statute, and that's the Commonwealth's perspective. And that's what McGee holds, and that's what Dabney
Recruit,
holds.
entice, or obtain by any means, statute.
Correct, there's no word of force.
Right, well, I mean,
And-
actually, in Dabney, we wrote coercion is not part of it, or harm isn't
But
part
if
of it.
I may respond, and this is again getting back to Justice Kafker's point of this idea that, well, aren't we criminalizing the same conduct?
Well, we have the
under
right to
two-
do that. The government can do that. We do that in the drug cases all the time.
And that is, it's discretion that is vested in the executive branch as to which penalty.
As long as the legislature's clear
Right.
that the government has basically 2 arrows to shoot.
And, well, that's not entirely true, Your Honor, because in those cases where there are different statutes, the statutes themselves don't say the government is entitled to choose. That is what this court infers by the existence of those two statutes.
If the offense conduct is clearly encapsulated in 2 different statutes, sure, it's your discretion to charge murder or manslaughter.
This court's own language has said that this is a clear and unambiguous statute, and the words
But
themselves are
the
not
court
ambiguous.
has not, court has always, the cases that you're referring to have been dealing with classic traffickers. They haven't been dealing with Johns, right? This is the first time we're dealing with whether what is traditionally understood to be a John is a trafficker, right? The other cases, I mean, if you look at them, they're all discussions of classic traffickers, right? They're not like we're dealing with here.
I'm not disputing that, Your Honor, but as this court has found, the legislative intent for this statute has been to take the victims of human trafficking out of the statute.
I totally agree with you, but you're actually, that's not the victims, we're not prosecuting the victims here. We're prosecuting the Johns as traffickers, and that is a different problem than one we've addressed so far.
But according to, again, the plain language of the statute, this
Language isn't
conduct,
that plain.
well, with respect to recruit, where this court has defined it as to hire for the services of, this squarely fits in that. As
Well,
to
let's
obtain, which
say
is
obtain, yeah, like focus on obtain, because I
Obtain-
think, at least as to me, recruit is a losing battle, but obtain, that one has some legs.
And it is intentionally broad. And the dictionary definition of obtain is to attain by some planned action or effort.
So what do we say, what do we do with the fact that the statute actually does say what constitutes the crime of trafficking persons, which I think is, to Justice Kafker's point, is that traditionally the traffickers are the suppliers minus the actual sex worker. Why does the word trafficking not have some bearing on how we construe obtain?
Because trafficking is defined by the legislature as the series of words used in that statute.
But it uses the word trafficking.
In the title, but in...
No. In the actual 50A, it says, attempts to recruit, entice, or obtain by any means that person shall be guilty of the crime of trafficking persons. And I'm wondering why trafficking in the statute itself, not in the title, but in the statute itself, doesn't inform what obtain should mean. What's your best argument that it shouldn't?
My argument is that those series of words shall be guilty of the crime of trafficking. That is defining these things create...
How do you define trafficking?
as someone who entices, recruits, obtains.
So it's a
by
circular
any-
definition in your,
Circular, Your Honor. I'm suggesting that the conduct outlined by the legislature is what constitutes the crime of trafficking.
Doesn't every John obtain, again, won't every John be obtaining?
Yes,
So every John is a trafficker?
yes, Your Honor.
So every John is a 5-year penalty then?
And so this is my concern with the court. The court is focusing on the 5-year mandatory minimum, and I understand that that is a significant penalty, but that is a penalty that the legislature is entitled to enact, and moreover, this is not an issue of cruel or unusual punishment because these defendants have not yet been convicted. So I would suggest that the penalty must be divorced by how the court is
I'm just trying to
thinking.
figure out, and, just asking questions here, not telling you what our decision is, so you should understand that. And when you say what the court seems to be concerned about. My question to you is why obtain shouldn't be informed by what people think of as trafficking? Because or is it, here I'll throw you a softball, which I thought you would have picked up, which is that, in Youngers, for example, that case defines trafficking as the business, both the supply side and the demand side of commercial sex.
Right.
Is that a position that the government's taking?
Yes, Your Honor, and I would also suggest, as I do in my brief, that the entire intent of the statute is to focus on the demand and the business of commercial sexual
Well, it's
trafficking.
certainly not just the demand. It's certainly got a lot of supply side. Recruit, entice, harbor, transport, provide. Those all seem supply side, not the sex worker, but all the supply side. So when you said that in your brief, I paused and wondered, the only thing to me is talking about the demand side potentially is obtain.
Or recruit or entice, I would suggest.
Okay.
Maybe not in this context, but in general, those would also apply to the demand side of human trafficking.
But before we lose you, can you address the two issues that remain, that being predisposition, which seems, as has been argued, is an added element by the appeals court, and secondly, the attempt ruling?
So with respect, if I could first address if Your Honor is asking about the factual impossibility, is that, yes. So this court affirmed Commonwealth v. Bell in Dissler, and so I would suggest that in the context of an attempt crime, factual impossibility is certainly not a defense. And especially here where we go so far as to even have an overt act of these individuals showing up for the commercial sexual services they contracted for, that certainly.
Undercover police work would kind of be blown if that was the case, right?
I'm sorry.
Undercover police work would kind of be a nullity if that were the case, right?
It would be. As would the idea of attempt generally, I would suggest, even outside of the context of undercover police work. And then beyond that, with respect, I apologize.
Predisposition.
The predisposition. So again, absent from this statute is any mention about a victim's predisposition. And so I'd suggest that what the appeals court erroneously did was insert an element that does not exist in the statute. And so I would suggest that was error, and I would ask this court to not imbue an element that does not exist in the plain language.
Will we ask if there are further questions?
Thank you.
Mr. Noonan?
Morning, Your Honors. My name is Patrick Noonan. I represent Brendan Garafalo, and I'm giving the arguments on all appellees. With me is co-counsel Sabrina Bohano, as well as co-counsels for all other defendants in this case. Just addressing some of the issues that were just raised by the court. Justice Wendland is correct in that the statute does say trafficking in it in the Black's Law Dictionary of trafficking or trading or dealing, usually in narcotics. So we're dealing with a circulation in commerce in the supply side of things.
But trade implies both the supply and demand side, so I don't see how that helps you.
Right.
For trading and dealing in the narcotics context is somebody that's putting the drugs out there, whereas somebody who's buying it is usually somebody who's a possessor.
Well, you're relying on the colloquial understanding of this, and I think what counsel, Attorney Campbell's been relying on is the words of the statute. Can you look at the words of the statute, not the colloquial, what everybody thinks it means?
I'm sorry, Your Honor. So for the words of the statute, I think that The appeals court got it right in terms of enticement. The appeals court first looked at the proper definitions of enticement, which are to instigate or incite, which require acts of initiation. Here, it's our contention that the defendants weren't initiating this concept of engaging in commercial sexual activity. Under enticement, the offer was made by the police by putting this advertisement up, which was very, very specific in listing what the services were. So the appeals court, in looking at entice and recruit, was looking at conduct which is initiating some sort of response. So like for recruit, good analogy for Justice Gaziano would be a college recruit going after an athlete. You know, would you like to play for our school? Here's the offer. If you're interested, then you're on the team. So here, those two, entice and recruit, require some acts of initiation, and here was the government that did it. The defendants replied, and then when they had the dialogue, certainly the defendants offered to pay for sex, and they agreed to engage in sex, which is exactly what the sex for a fee statute prohibits. It has that statutory language in there. It's very
So why
plain and
didn't they
clear.
attempt to obtain by any means another person?
So I would say that the appeals court got it right when they're talking about what obtain means, which is to possess, and then when
So
you
you're
look at
saying they didn't attempt to possess another person?
So with possess, the statutory language is also another person. To possess another person, possession is also connoting control over that person, and you're somewhat trying to change the person's will or intention to engage in the activity. So that's what the appeals court was saying when they were looking at obtain.
That's where I think you run into problems. I don't see where the word obtains plain and ordinary meaning requires a changing of minds.
Well, the appeals court looked at the definition of obtain, Black's law, to get, retain control, to get, retain possession. Obtain is, if in the government's view, is just going to be so overly broad, and I don't think that this is going to, this shouldn't cast such a wide net to get every single
But why not?
John.
I mean, I think we've said before that the legislative intent of this statute was to allow the state, as opposed to waiting for the feds to have the resources, to police this kind of conduct. And by not having coercion, force, or fraud, expanding what the state officers can do to pursue trafficking.
I also think that the legislative intent of the sex for a fee statute was to increase the penalty for those
But
who
we
buy
have
sex.
statutes that overlap, so I guess I'm not so persuaded by the fact that there is a separate statute that can be used to punish Johns. So I guess I'm wondering why a purchaser of commercial sex is not obtaining somebody. Why are you buying into or supporting or arguing for the canon of construction used by the appeals court that lists somehow narrow the generic term at the end of the list? And then if so, can you explain to me how this particular list narrows obtain?
So I think that the appeals court properly applied the doctrine because obtain, in the context of sex trafficking, hasn't yet been addressed by the court, so.
Well,
in
that's
using
not
that-
why that canon of construction applies. It doesn't always apply when the court hasn't yet construed something. It applies more narrowly when there's a list, and all of these things in the list have something in common. And then there's this generic term at the end that could really swallow the whole.
So I was kind of addressing what the Commonwealth was saying in their brief, that the doctrine only applies if the statute's ambiguous, but here obtain wasn't really yet addressed by the courts. But with general words following specific words and so forth, the preceding words for obtain are harbor and transport, which require some physical, physically affecting the person's condition. So for that,
But it's
for the
not,
doctrine.
the full list is recruit, entice, harbor, transport, provide.
So entice, recruit are initiating conduct, which is not present here. Harbor, transport is somehow physically affecting the other person's condition. which is not present
Is there
here.
ever a situation where the list doesn't have just one thing in common, but has these things in common that you're suggesting? One is about somebody not predisposed to do something, and then somebody's physical possession?
Well,
I've not seen the doctrine applied in that way.
The doctrine, I think, is Latin for this, similar in kind. So if we
Right,
we
so
go
they,
back,
all of these things need to be similar in kind to something. What is that thing?
Aren't they similar in kind to trafficking? If you go through each word, you recruit them for trafficking. You entice them to traffic. You harbor them. You transport them. The only one and obtain in that context sounds like classic trafficker. You obtain them from and turn them into prostitutes.
not what, I mean, so.
I'm making an argument for you.
Yes.
'Cause I,
Yes, I'm sorry. I'll let you finish. Yes, but
Does that really help you, though? I mean, let's talk practically. So to Justice Caffer's point about whether or not you can obtain them and turn them into trafficking, we've already said you can't traffic yourself,
Yeah.
right? So somebody's got to be paying you to be trafficking. So why is it such a controversial construction of Section 50 that, yeah, if you go out and solicit commercial sexual activity, you are trafficking. And it's different than the other, because back to Attorney Campbell's point, this talks about folks that don't necessarily exchange currency. That's the other statute, right? That's the other statute that they amended to give the 2.5 years at the same time. This captures the folks like your client and all these other folks who never got to the point of exchanging currency. But yet we would have no human trafficking if we had no Johns, because you can't traffic yourself. So why is this controversial to say that this statute doesn't necessarily, the legislature didn't intend to sweep up Johns when they say obtain by any other means?
well, if we look at what was the defendant's intention in responding to the ad? Was their intention was to pay for sex, and they had an agreement to pay for
Right,
sex.
they
and that's-
intended to obtain by any means another person. I don't really understand the
If we look at-
ambiguity there.
If we look at every single sort of sex trafficking case in Massachusetts where convictions were affirmed, we're dealing with a defendant who approaches a victim and introduces the concept of engaging in commercial sexual activity, and then is essentially putting them out there to engage in sex with other customers. And it's somewhat part of an operation. There's no sort of.
But that would
there's
make
no-
sense if the legislature did not decide to add the words obtain. That's where I get stuck.
And you also, back to Justice Wetland's point, you're only looking at half the equation. You're only focusing on the supply. Well, there's also a demand side.
Which is sex for a fee.
Well, no, it's not, because sex force fee is when you actually pay for it.
offer to pay.
Offered, okay.
Exactly what happened.
Well, we already,
And what we're going to do is we're going to take every single John in this particular, we're going to take every single John and we're going to charge him with sex trafficking and we're going to put him in prison for 5 years. I don't think that was the intent of the statute.
Why?
If the government,
Why do
why-
you
why
say
wouldn't
that?
it
Why
be?
was that not the intent?
because the intent to punish the Johns was to increase the penalty to 2.5 years, which what the legislature did at the same time that they enacted the sex trafficking statute. And if the
Legislative history that helps inform this? I don't remember, is your brief, have you gone to, do we have the sort of full file here? Because we're starting to get to issues of legislative intent here.
I
Do
think
we
the
have any, did you do a review of the legislative history?
But
Find anything useful?
So the appeals court, in looking at the legislative intent, was both of those, the sex trafficking statutes passed in 2011, and at the same time, the sex for a fee statute is revised, which it has been in existence for a very, very long time. So it was revised at the same time as the sex trafficking statute to enhance the penalties for the people that buy sex.
So when you get to legislative history, you have to find some ambiguity in the statute. And I'm wondering why the word obtain is ambiguous, so that we have to get into legislative history. Because usually the best evidence of legislative intent are the words that the legislature chose.
Well, I would just say that the legislative intent to punish this conduct the legislators chose the sex for fee statute, they chose the language for the sex for fee statute, and that's with conduct that was
No,
violated.
but that's a
in this
different
case.
statute. Usually when we construe one statute, we look at the words of that statute. So looking at the trafficking statute, why would the legislature have used the word obtain by any means another person if they didn't mean to capture the purchasers?
I can't speak for what the legislative intent was for putting that particular word in the statute.
Is it so broad that it's ambiguous?
I think that it's not putting the defendants on notice of what conduct is prohibited by saying obtained by any means. It's
Well, it's
very
certainly,
ambiguous.
they're on notice, it's criminal conduct, correct?
Sure, but obtained by any means, you still have to have a statute with sufficient clarity to put people on notice of what's punished. So maybe somebody looks at this and they don't know, they can say, I'm violating the sex for fee statute by agreeing to engage in conduct with a prostitute, but I'm not. Am I obtaining that person and therefore violating the trafficking statute? That's kind of an issue.
I don't think
would-
people need, I don't think the ambiguity jurisprudence says that you have to know the penalty. You have to know it's a crime. Go on.
I mean, classic obtain by any means had two possible definitions. The one, just what we're talking about, it covers the Johns because they've obtained. The other is obtain by any means, meaning you obtain the sex worker by some means, any means. If you brought them in, you offered them drugs, you did whatever,
Or money.
or money, meaning you offered them to be a sex worker as opposed to, paying cash for the sex. I mean, whether this is a John statute or a trafficker statute isn't clear to me. But apparently, at least according to the appeals court, the legislative history isn't going to be that informative either. It's all over the place.
But I think obtain, similar to the words preceding it with entice recruits, still require that element of initiation.
So you need an ambiguity to get to the statutory construction of words assessed by the company they keep and/or the rule of lenity, correct?
I'm sorry.
The rule of lenity,
Yeah.
right, which means that the
Yes.
tie goes to the defendant.
Sure. And there could be an issue here with obtained by any means being
If-
ambiguous to the point where the rule of lenity would apply.
Was that something that you argued?
That's yes, it was argued in the lower court. It was in
That
the motion.
that the statute is ambiguous and so we should apply the rule of lenity?
Yes, it was argued in, it's in the motion to dismiss filed in the Superior Court. That was raised as one of the issues as well.
Did you raise it in your brief?
No, but this is a de novo review, so I think that the record would.
Can you talk about impossibility?
Yes, we were seizing on the language in the Fan case.
But FAN has to do with the identification of particular people, their names, because people come and go, not that it still has to be a person.
Right, and the language we were seizing on was the Commonwealth must prove that there was a victim, i.e. someone that the defendant enabled or caused to engage in commercial sexual activity. And then looking at the Pompolis case, they were looking at the statute intending to punish conduct directed at a discrete victim and conduct that's injurious to a victim. And then the model jury instructions were revised after FAN, or right around FAN, where they included in parentheses, harbor, transport, et cetera, in parentheses, alleged victim. Here, Commonwealth, when presenting this indictment, was identifying the victim as society. And so I think that the indictment should be dismissed there, but
But we also did, in FAN, we didn't deal with attempts, did we?
But I think that the entirety, I think, of Section 50A was addressed in the decision, so I thought that would encompass the attempt as well, because the FAN court, I think, was looking at 50A, all the language that was used in it, including attempt. If there are no other questions, I would.
Thank you,
Thank you so much.